All right, good morning. Good morning, everyone. Welcome to the inaugural edition of the National Law School SIAC Annual Arbitration Lecture. This will be delivered by Dr. Claudia Nacker shortly. My name is Hari Shankar. I teach international arbitration law here at the law school. And I take this opportunity to welcome Claudia, Pramod, Shweta, and Pranav, and people from the audience, my students, faculty colleagues, and officers of the Indian Trade Service. Thanks for joining. The National Law School of India University is excited to join hands with the Singapore International Arbitration Center in organizing this series of annual arbitration lectures. And this is one of the key activities that we have with the SIAC as part of a memorandum of understanding that we have with the Singapore International Arbitration Center. We are also running a special elective course this week on SIAC and institutional arbitration. And I take this opportunity to thank Shweta Biduri, Steffi, and Pranav, and the rest of the team at the Singapore International Arbitration Center for all the support. And the topic for today's lecture is sunset clause. Is a very pertinent topic for Indian bilateral investment treaties and India-related investment treaty disputes. And talk about this sunset clause. We have two speakers. And actually is an independent arbitrator and counsel specializing in international arbitration and public international law, in particular disputes involving international organizations and human rights cases. In private arbitration as well as and state arbitration. She's a arbitration of arbitration. Been a visiting professor at the Paris West Nanterre La Défense University, and she regularly teaches at different universities around the world. She has published widely in the fields of public international law and international arbitration. Welcome, Claudia. And before I hand over the mic to Claudia, I'm also joined by Mr. Pramod Nair, who is a distinguished alumnus of this university. Pramod has an LLM from the University of Cambridge, and he has over 20 years of experience in the profession. He's currently a senior advocate at the High Court of Karnataka, and advocate of the Law Society of England and Wales. He also has a law school and is a part of the teaching team of the current course that we are having with the SIAC. And with that opening remarks, I request Pramod to start the session by briefly introducing the topic.
Thank you, Hari, for that wonderful opening address. And it's really a privilege to be with all of you here today. It's especially a privilege to welcome Claudia, members of the SIAC team. And it's especially wonderful to have this inaugural event at the National Law School today. And I think it's a collaboration which augurs very well for the future. We have a fantastic speaker who I'm sure will have a lot to speak about. So I don't want to spend too much time standing between her and the lecture. So let me make my opening comments very short. So I think it's, as Hari mentioned, this topic is a topic which has a special resonance for India. Many of you would be aware of the decision in White Industries, which sparked off a chain of termination of a number of India's bilateral investment treaties. I think India was a party to close to 80 bilateral investment treaties and free trade agreements with investment chapters. Over 70 of those treaties have now been terminated unilaterally by the Republic of India. Although this was accompanied by the crafting of a new model India BIT, which was intended to be the template for future investment treaties that India would embark upon. Not something which has gained much traction. I think the number of investment treaties that have been signed pursuant to the unilateral termination of India's BITs is in the low single. Therefore, this is a topic that has a lot of significance for India because the first wave of denunciations and termination of the BIT happened in 2016. BITs typically provide that those treaties will continue to operate and have full force and effect for a period of between 5 to 15 years, depending on the treaty in question. And contained in BITs. And therefore, the real purpose is to ensure that their legitimate expectations are protected for a period of time which can range from, in some cases, 5 years to probably 20 years in some cases. And it's also something which has been invoked in the Indian context. Even after the termination of India's BITs, notices for arbitration are still being received by the government of India in respect of investments that were made prior to the termination of India's BITs. So I'm sure we will have a wonderful discussion and an enunciation of this very, very crucial and important topic today. And I, as much as every one of you, look very much forward to hearing from Claudio on this very interesting and important topic. Thank you, Claudio.
Thank you very much. Good morning, ladies and gentlemen. It is my privilege to address you today on sunset clauses in bilateral investment treaties. Now, virtually all bilateral investment treaties feature so-called sunset clauses or survival clauses. A 2013 OECD study that surveyed more than 2,060 bilateral investment treaties shows that only 1% of all bilateral investment treaties have no sunset clauses. Now, as Pramod mentioned, sunset clauses extend the protections accorded to investors under investment treaties for a certain period of time after the treaty's termination. The India-Netherlands BIT, for example, which I put up on the screen, provides in Article 16, paragraph 1, and that's a typical sunset clause, in respect of investments made before the date of the termination of the present agreement. The foregoing article shall continue to be effective for a further period of 15 years from that date. Now, although already the very first bilateral investment treaty concluded between Pakistan and Germany in 1959 contained a sunset clause, and also sunset clauses have become an almost universal feature of bilateral investment treaties, sunset clauses have received little attention in the past. But they have been put in the spotlight more recently, when states started to terminate bilateral investment treaties, either to free them of their treaty obligations altogether, or to renegotiate their BITs in the context of the ongoing ISDS reform process. In fact, hundreds of bilateral investment treaties have already been replaced or are in the process of being replaced, either with renegotiated BITs or with investment chapters of free trade agreements or regional economic integration treaties. Beginning in 2016, India terminated more than 75 bilateral investment treaties, and it did so to replace these with treaties that conform to the 2015 Indian model BIT. Now, India terminated these BITs in accordance with the treaty's provisions on unilateral termination, denunciation of the treaty, allowing each state after a certain period of time to terminate the treaty by notifying the other contracting state of its intention to withdraw. Now, these terminations triggered the sunset clauses in the denounced treaties, typically 10 or 15 years. The sunset period is the period during which the contracting states remain locked into their treaty obligations. In India, it currently faces several investment treaty claims under these terminated BITs, and Indian investors have also availed themselves of sunset protections available to them under terminated bilateral investment treaties. So, for example, a UK subsidiary of the Japanese company Mitsui and GPIX, a Mauritius shareholder in an Indian airport services company, they have brought claims under terminated Indian BITs, the UK and the Mauritius India BITs, and Pantera Resources Australian subsidiary IndoGold notified India of the dispute under the terminated Australia-India BIT. Conversely, Patel Engineering has brought claims against Mozambique under the terminated India-Mozambique BIT, invoking the sunset clause of that bilateral investment treaty. Now, in addition, the member states of the European Union have terminated all bilateral investment treaties in force among them, and they did so to comply to a judgment of the highest court in the European Union, the Court of Justice of the European Union, which ruled in March 2018 in the famous Agnia case that investor-state arbitration under so-called intra-EU bilateral investment treaties is incompatible with European Union law. Now, notwithstanding this judgment from the highest court in the European Union, investment treaty tribunals seized with intra-EU BIT claims continue to adjudicate such claims. In May 2020, 23 EU member states eventually entered into a treaty, the EU Termination Agreement, and that treaty provides for the termination of their intra-EU bilateral investment treaties, but the treaty not only terminated about 130 bilateral investment treaties, the treaty also expressly terminated the sunset clauses of those treaties, providing that sunset clauses in the terminated BITs, as well as in BITs previously terminated by EU member states, quote, shall not produce legal effects. Finally, by way of further example, the 1994 Energy Charter Treaty, a multilateral investment treaty that protects investments in the Energy Charter Treaty, has been subject to a modernization process since 2018. Now, dissatisfied with the efforts made to align the treaty with the climate change goals in the Paris Agreement, several EU member states withdrew from the Energy Charter Treaty. Now, the Council of the European Union announced recently that the European Union itself will also withdraw from the treaty, and the United Kingdom confirmed in February this year that it will also withdraw from the Energy Charter Treaty process. Each of these efforts to terminate, replace, or renegotiate the ITs faces potentially a major obstacle. The sunset clauses in these treaties, indeed, in the current transitional stage of the investment treaty system, these sunset clauses may become a key issue for contracting states to bilateral investment treaties. Combined with minimum validity periods, sunset clauses have the effect of locking states into their investment treaties for substantial periods, on average more than 20 years. And under some BITs, such as the Korea-Kuwait BIT or the Malaysia-UAE BIT, the contracting states even remain bound by their treaty obligations for half a century. Our sunset clauses differ, in particular in terms of the length of sunset periods and the conditions that trigger the sunset protections. The length of sunset periods varies significantly, ranging from 5 to 20 years. At least one BIT, that's the Korea-France BIT, seems to extend protection for existing investments indefinitely after the treaty's enunciation. Most investment treaties provide for a 10-year sunset period. Surprisingly, the length of the sunset period does not depend on the nature of the investment or the time it will take to repatriate the investment. The OECD study identified a single BIT, the France-Costa Rica BIT, whose sunset clause differentiates between investments. The BIT contains a general 15-year sunset period, but a 20-year sunset period for investments made in the mineral sector. Our sunset clauses usually apply to investments that have already been made prior to the effective date of a BIT's termination, occasionally prior to the notice of termination, but not to new investments made after the treaty's termination. Now, there are a few investment treaties that accord sunset protection to investments that have not yet been made, but that have been committed or approved prior to termination. The operation of sunset clauses following unilateral termination of a BIT has not given rise to much difficulty or controversy. Pursuant to their plain terms, sunset clauses invariably grant further substantive treaty protections and investor state arbitration clauses for existing investments, thus allowing investors to bring investment treaty claims for predetermination breaches and treaty violations during the sunset period. Several investment treaty tribunals have established jurisdiction based on sunset clauses. Now, Italy was the first EU member state that withdrew from the Energy Charter Treaty, effective as of January 1st, 2016. Now, Italy nonetheless faces the second highest number of claims under the Energy Charter Treaty in response to Italy's reduction of feed-in tariffs for solar power plants. A flurry of claims has been brought against Italy under the Energy Charter Treaty, invoking that treaty's 20-year sunset clause. Our tribunals have had no hesitation to hear and decide such claims. The operation of a sunset clause in the event of unilateral termination seems to have been in dispute in only one case. Now, in long-read investments versus Venezuela, Venezuela argued that the sunset clause of the Netherlands-Venezuela BIT grandfathered only the substantive treaty protections of the BIT, but not the investor's state arbitration clause. According to Venezuela, by terminating the BIT, it withdrew its standing offer to arbitrate, and Dutch investors who had not accepted the offer before the termination could not accept it thereafter. The sunset clause of the Netherlands-Venezuela BIT provides that in respect of investments made before the date of termination, the quote foregoing articles of the treaty shall continue to be effective for 15 years. Now, the foregoing articles obviously includes the investor's state arbitration clause in Article 9 of the treaty. So the tribunal swiftly rejected Venezuela's argument by pointing to the plain terms of the sunset clause of the Netherlands-Venezuela BIT. Now, the question whether sunset clauses apply if a BIT is terminated by mutual consent of the contracting states is less straightforward. This question is of critical importance in the context of the ongoing ISDS reform process, which features consensual terminations and renegotiations of bilateral investment treaties. The answer depends, in the first instance, on the specific terms of the sunset clause in the applicable investment treaty. Some sunset clauses refer to notice of withdrawal or termination in accordance with the provisions of the treaty that governs unilateral termination. The sunset clause of the Singapore United Arab Emirates BIT, for example, which I put up on the screen, provides in respect of investments made prior to the date when the notice of termination of this agreement becomes effective, the provisions of this agreement shall remain in force for a further period of 15 years from that date. So this sunset clause applies only in the event of unilateral termination, not termination by mutual consent. Most sunset clauses, however, are ambiguous as to whether they also apply in the event of consensual termination. Unfortunately, there are many sunset clauses that are quite poorly drafted. For example, there are contradicting sunset periods, 20 years and 10 years, in the South Africa Kuwait BIT. The sunset clause of the Spain-Ethiopia BIT excludes Article 1, the definitions of the treaty, and the sunset clause of the 1990 Spain-Bolivia BIT refers only to Articles 1 and 2, but not the substantive protections and the investor state arbitration clause. When it comes to the question whether mutual or only unilateral termination trigger the sunset clause, most bilateral investment treaties refer to termination without further qualification. So the sunset clause of the Japan-Pakistan BIT, for example, reads as follows: in respect of investments and returns acquired prior to the date of termination of the present agreement, the provisions of Articles 1 to 13 shall continue to be effective for a further period of 15 years from the date of termination of the present agreement. Now, under its plain language, this sunset clause is triggered by any kind of termination of the BIT. A contextual interpretation may suggest, however, that this sunset clause and similarly worded sunset clauses apply only in the case of unilateral termination. Now, BITs generally set forth only the conditions for unilateral termination of the treaty, not for consensual termination. And sunset clauses are typically part of the same paragraph that governs the treaty's denunciation, or they are included in the separate but immediately following paragraph. The sunset clause of the Japan-Pakistan BIT is included in paragraph 3 of Article 14. Paragraph 2 of this article provides either contracting party may, by giving 1 year's advance notice in writing to the other contracting party, terminate the present agreement at the end of the initial 10-year period or at any time thereafter. So if read in conjunction with paragraph 2, the sunset clause may cover only unilateral termination. Our investment treaty jurisprudence on the scope of sunset clauses is scarce. So far, no investment treaty tribunal seems to have engaged in a detailed legal analysis of whether sunset clauses apply only to unilateral terminations or also to consensual terminations. Now, in Gavazzi versus Romania, the tribunal applied the Italy-Romania BIT, which was terminated by mutual consent, and which contains a 5-year sunset clause. The investor initiated exit arbitration in 2012 during the BIT's sunset period. The tribunal simply noted in footnote 1 of its award, the BIT was terminated on March 14, 2010, subject to the sunset provision in Article 11, paragraph 3. The applicability of the sunset clause was not disputed, even though the clause refers to, quote, the above mentioned dates. Those are the dates in the BIT's clause on denunciation, unilateral termination of the treaty. I would interject that the sunset clause of the Italy-Romania BIT is another example of a sunset clause that suffers from obvious drafting oversights. The sunset clause identifies the articles surviving the BIT's expiration as articles 1 to 1 parent. The Madhya Farming Tribunal also interpreted a sunset clause as applying in the event of consensual termination of the BIT. The tribunal interpreted the sunset clause in the United Kingdom Hungary BIT, which provides that the treaty's provisions shall continue in effect for 20 years after, quote, the date of termination, with respect to investments made while the treaty was in force. During the pendency of this arbitration, the Court of Justice of the European Union rendered the clear judgment. And the United Kingdom and Hungary together issued a declaration to the effect that the BIT's investor state arbitration clause was inapplicable due to its incompatibility with European Union law. Now, in this context, the tribunal stated, this provision, the sunset clause, shows that even where the contracting parties terminate the treaty on mutual consent, they acknowledge that long-term interests of investors who have invested in the host state in reliance on the treaty guarantees must be respected. This is the purpose served by the 20-year sunset provision. The tribunal in Eastern Sugar versus Czech Republic expressed the same view in rejecting an argument by the Czech Republic that its accession to the European Union terminated the Netherlands Czech Republic BIT, together with that BIT's sunset clause. Some investment treaty tribunals have interpreted sunset clauses in the context of successive BITs, replacements of BITs in the context of renegotiations. So in Bagat versus Egypt, the tribunal interpreted the sunset clause of the 1980 Egypt-Finland BIT, which was replaced in 2004. The 2004 BIT provides that upon its entry into force, it substitutes and it replaces the 1980 BIT, but without specifically mentioning the fate of the sunset clauses in the 1980 BIT. The tribunal rejected Egypt's position that the sunset clause covers only unilateral termination, and it concluded, based on a literal interpretation, that investors following any kind of termination of investment protections should benefit from the survival clause. The tribunal in Weiterbau versus Thailand also considered that the 1961 Germany-Thailand BIT sunset clause survived that treaty's replacement in 2002. The 2002 Germany-Thailand BIT, like the 2004 Egypt-Finland BIT, expressly terminated the previous BIT, but without mentioning the BIT's sunset clause. Now, on the other hand, at least one tribunal accepted that mutual termination and replacement of a BIT did not trigger the sunset clause in the replaced BIT. That was the tribunal in Ping An Life Insurance Company versus Belgium. That tribunal observed that the substitution and replacement of the 1984 China, Belgium, Luxembourg BIT did not trigger the sunset clause of that bid because the treaty had not expired. And so the conclusion was based on the specific terms of the sunset clause of the China, Belgium, Luxembourg BIT, which covers investments made before the date of expiration of the treaty, which continue to be protected for 10 years, again, from the date of expiration of the treaty. Another tribunal considered that a BIT's termination and replacement would trigger the sunset clause unless the contracting states amended or revoked the sunset clause. Now, in rejecting Hungary's argument that the arbitration clause was terminated following its accession to the European Union, the UPNCD tribunal noted that the BIT's sunset clause, quote, does not contain any limitation or exception as to its application, and it would thus apply even if the BIT had been terminated. The tribunal accepted the contracting states have the power to amend and possibly even to revoke sunset clauses, but consensual termination of a treaty in itself does not reside in the revocation of the sunset clause. So in each of these cases, the applicability of the sunset clause was either not disputed or the statements by tribunals were made in obiter dicta without any or very little legal analysis. So these cases offer only limited, quite limited guidance on how investment treaty tribunals will assess the scope and the effect of sunset clauses in the context of recent consensual BIT terminations. If a sunset clause applies in the event of a treaty's consensual termination, the question arises whether the contracting states may eliminate, neutralize the effects of a sunset clause, and if so, how? Now, under the law of treaties, states are the masters of their treaties. Pursuant to Article 54, Liter B of the Vienna Convention on the Law of Treaties, they may terminate a treaty at any time by consent, and they may do so regardless of the specific procedures or conditions provided in a treaty for its termination. Now, the legal consequences of the termination of a treaty are set forth in Article 70, paragraph 1 of the Vienna Convention. Unless the contracting states otherwise agree, the termination of a treaty does not affect any right, obligation, or legal situation of the parties created through the execution of the treaty prior to its termination. Now, on its face, and as expressly confirmed by the International Law Commission, Article 70 only protects the rights of the contracting states, of the parties, refers to the contracting states, not rights of third parties, such as investors. Now, some investment treaty tribunals have nevertheless interpreted Article 70 as applying to the rights of investors. For example, the tribunal in Ostrakedel versus Slovakia and Eastern Sugar versus Czech Republic observed in obiter dictum that even if the BIT had been terminated, then the investors' rights prior to the termination would have remained unchanged in accordance with Article 70 of the Vienna Convention. Now, in any event, under the express terms of Article 70, the contracting states to a bilateral investment treaty are free to determine the consequences of the treaty's termination, including to revoke sunset clauses. Now, the Vienna Convention does contain 2 articles that restrain the contracting parties' power to revoke rights of third parties. Pursuant to Article 37, paragraph 2, the contracting states cannot revoke rights of a third state without that state's consent if, quote, it is established that the right was intended not to be revocable without that state's consent. This rule applies solely to the rights of states. The rule applies even to international organizations only if the international organization consented to the grant of the right in the first instance. It would be quite difficult to try to extend this rule to rights afforded to investors under investment treaties. Now, investors do not consent to the rights granted to them under investment treaties. Virtually all investment treaties contain termination provisions authorizing a contracting state to denounce the treaty without the consent of protected investors. And since investment treaties protect an indeterminate class of investors, termination by consent would be practically excluded if conditioned on each protected investor's consent. Now, the Vienna Convention does contain a provision that protects individuals against treaty termination. That's Article 60, paragraph 5. But this article protects only against unilateral termination of treaties and only of treaties of a humanitarian character, such as the Genocide Convention or the Geneva Conventions. And only in one instance, unilateral termination in response to a material treaty violation by another contracting state. So the Vienna Convention contains no other provisions protecting individuals or protecting legal persons in the context of treaty termination. Since the Vienna Convention on the Law of Treaties is otherwise silent on the rights of individuals and legal persons in the context of treaty termination, we must turn to customary international law and to the general principles of law to determine possible limitations on the contracting state's power to revoke sunset clauses. Now, under the prevailing view, investment treaties confer direct rights on investors, not only on the contracting states. However, this does not, as such, deprive the contracting states of their power to revoke these rights. Oh, it has been argued that the contracting states, even by consent, cannot divest investors of their rights under investment treaties before the sunset period expires. Now, at least one investment treaty tribunal, the Madhya Farming Tribunal, seems to have endorsed this theory. The tribunal stated, the BIT is an international treaty that confers rights on private parties, while the contracting states remain the masters of their treaty. Their control is limited by the general principles of legal certainty and res inter alias acta, alias nec nocet de codex. Oh, the extinction of sunset clauses with immediate effect is indeed at odds with the very purpose of sunset clauses, to balance the interests of investors in legal stability and legal certainty regarding the application of investment treaty protection on the one hand, and the state's sovereign right to terminate treaties on the other. There is, however, little support for the proposition that general principles of law do prohibit states from revoking sunset clauses in their BITs. Now, investors have invoked their legitimate expectations regarding the application of a BIT's sunset clause, but in 2018, the International Court of Justice held in a case brought by Bolivia against Chile, obligation to negotiate access to the Pacific Ocean, that the concept of legitimate expectations, very well established under investment treaties, under the fair and equitable treatment standard, does not form part of customary international law. Our respect for acquired rights is a general principle of law. But in practice, the principle has applied virtually exclusively in the context of state succession with respect to private rights granted to private persons under domestic law. The principle does not seem to have applied to rights granted to individuals or legal persons under treaties, and not in the context of a treaty's termination. Now, even in the context of human rights treaties, consensual terminations have not been considered limited by the acquired rights of individuals. When North Korea attempted to withdraw from the International Covenant on Civil and Political Rights in 1997, the UN Secretary General, acting as the depository for the covenant, acknowledged that North Korea's withdrawal would be possible if all contracting states agreed. The proposition that investor rights are irrevocable during the sunset period is also squarely contradicted by state practice. Most recently, the EU termination agreement concluded by 23 EU member states, which terminated the sunset clauses with immediate effect and stated that they shall not produce any legal effects. Now, when Australia replaced its second generation BITs, the contracting parties likewise proceeded on the basis that they had the power to revoke the sunset clauses in the replaced BITs. The 2019 Australia-Hong Kong BIT provides that upon its entry into force, all provisions of the previous BIT, the 1993 BIT, including the sunset clause, shall cease to have effect. In 2019, Australia and Uruguay replaced when they replaced the 2001 BIT, they included a provision to the same BIT in the new treaty. The effects of recent consensual terminations of sunset clauses remain largely untested. So far, we have seen one investment treaty tribunal, the UPNC tribunal, accepting in obiter dictum that the contracting states may revoke or amend sunset clauses, while another tribunal, the Madhya Farming Tribunal, considered also in obiter dictum that investor states are irrevocable during the sunset period. Our investment treaty tribunals will soon have the opportunity to decide whether the recent consensual terminations of sunset clauses are effective. In 2020, LC a Dutch investment holding company, initiated arbitration based on the sunset clause of the Netherlands Poland BIT after the Netherlands and Poland terminated that treaty by mutual consent. In 2022, a Dutch property development company brought a claim under the terminated Netherlands-Romania BIT after that BIT, including its sunset clause, had been terminated by the EU termination agreement. And last year, a Bulgarian insurance company threatened a claim under the Bulgaria-Romania BIT, which was also terminated by the EU termination agreement, including the BIT's sunset clause. If contracting states are deemed to have the power to revoke sunset clauses, the question arises, how must they exercise their power in order to deprive the sunset clauses in the existing bilateral investment treaties of their effects? If contracting states terminate a BIT without specifically mentioning the BIT sunset clause, then the sunset clause arguably remains effective. To the extent that investment treaty tribunals accepted the contracting states' right to revoke sunset clauses, they have already hinted to the need for express termination of sunset clauses. Now, some states have taken a cautious approach. They attempted to avoid the effects of sunset clauses by first amending the BIT to eliminate the sunset clause, and then in the next step, terminating the treaty with immediate effect without the sunset clause. Now, it's questionable whether this approach changes much from a consensual termination in one step, but the Czech Republic, for example, took this approach when it terminated its BITs with Malta, Denmark, Italy, and Slovenia by consent. While Indonesia generally terminated its BITs unilaterally, like India, when Indonesia and Argentina replaced the 1995 Argentina-Indonesia BIT, it amended the BIT to remove the sunset clause. And Australia and Chile did the same when they replaced the 1996 Australia-Chile BIT in 2009 by a free trade agreement with an investment chapter. Other states have left sunset clauses in place, but they agreed to shorten the sunset period when they replaced their BITs. Now, this was the case when Australia terminated its BITs with Vietnam, Peru, and Mexico, following the entry into force of the Comprehensive and Progressive Agreement on Trans-Pacific Partnership. Recent investment treaty practice has already started to react to the uncertainties regarding the effects of sunset clauses in the event of mutual termination. For example, the sunset clauses of the 2019 EU Vietnam Investment Protection Agreement and the 2019 Slovakia Model BIT expressly subject any rights arising under the treaty sunset clauses to the contracting parties' right to revoke or to modify the sunset clauses. Now, even if the contracting states are deemed to have the power to terminate their BITs with immediate effect and to override sunset clauses, there are certainly limits. If an investor already initiated arbitration before the termination of the BIT takes effect, the termination will generally not deprive the investment treaty tribunal of jurisdiction. Now, this follows expressly from Article 25 of the ICSID Convention. Paragraph 1 provides when the parties have given their consent to ICSID arbitration, no party, including the respondent state, may withdraw its consent unilaterally. Now, this was most recently confirmed with elaborate analysis by the tribunal in Adria Group versus Croatia. While the arbitration was pending, the EU termination agreement entered into force. The tribunal even acknowledged that the contracting states to the EU termination agreement intended to terminate their BITs with retroactive effect on pending and even concluded investment treaty arbitrations, but it nevertheless upheld jurisdiction based on Article 25 of the ICSID Convention, pointing out that while Croatia and the Netherlands may well be regarded as the masters of their BIT, they're not masters of the ICSID Convention, a multilateral treaty with 158 contracting states. Non-ICSID tribunals may also be inclined to take the position that the contracting states cannot deprive them of jurisdiction by terminating the underlying BIT during the pendency of an arbitration. It is settled jurisprudence of the International Court of Justice and of investment treaty tribunals that the critical date for establishing jurisdiction is the date of the initiation of the proceedings. But none of the cases involve so far an attempt by contracting states to terminate a treaty retroactively so as to interfere with pending arbitrations or even concluded arbitrations. The legal consequences of consensual terminations that claim to have such retroactive effect for pending non-ICSID arbitrations therefore remain untested. Finally, even if the contracting states have the power to terminate their BITs by consent with retroactive effect, such termination may be a violation of their obligations under human rights treaties. To the extent that the termination would affect the awards already rendered prior to the effective date of termination, the termination may amount to an interference with property rights in violation of the right to property. And even if no award has been rendered in a pending arbitration, the interference may constitute unjustified interference in violation of the rule of law and of the notion of fair trial. Now, this concludes my lecture. Thank you for your attention, and I look forward to your questions and comments.
Thank you, that is as comprehensive as it gets. Thank you for giving us that wonderful exposition of a little explored area of law of investment treaties. I'm sure that there must be a number of questions from the students and participants. Yeah, because that you put your hand up and you would probably come to the stage and ask the question. That would probably be ideal. Now we have to ask this. Okay.
Thank you, ma'am. Thank you so much for your lecture. My question was precisely with the revocation of sunset clauses. If both of the parties mutually agree that the sunset clauses will not be acted, then would there be even a challenge from an investor saying that this mutual revocation does not affect my party rights, my rights that I mean. This was something that I could not.
The scenario is that the contracting states mutually terminate and they agree to terminate the sunset clause.
Yes. Mutual parties agree that they are going to terminate the sunset clauses, so the third party can again challenge that revocation on the ground that I have certain expectation, I have.
Absolutely. The investors have already voiced such positions, both inside and outside of investment treaty arbitrations. As I mentioned, we are at a very early stage. There are pending cases, but no concluding cases to test these consensual terminations. So investors will certainly argue we had a legitimate expectation, and the contracting states expressly state that in the event of termination, they will continue to protect their investments for a certain period of time. They may even come up with an stop loss. We've discussed before, there are various serious arguments why this might be an uphill battle, but this will certainly be an argument, legitimate expectations. And the strongest argument that investors will put forward is acquired rights. It's untested in the context of treaty rights. It's untested in the context of treaty termination. And we have never seen a consensual termination of the human rights treaty. So even in that context, we have no precedent. But acquired rights, as one tribunal already accepted, may indeed be very attractive to investment treaty tribunals to dismiss the attempt by the contracting states to get rid of the previously agreed sunset clauses in their existing PITs. Yes. Very good question, yeah. In principle, there wouldn't be a forum, certainly not an investor state tribunal, because the contracting state simply terminated, and that termination is effective. We have to distinguish between whether the termination is effective under the law of treaties and whether the termination is unlawful. It can be an internationally unlawful act and may still be effective. So what's the forum? There may be a regional human rights court, like the European Court of Human Rights, with jurisdiction over such a case, and then the domestic court. Investors will not like these avenues, but these will probably be the only avenues that are available to investors challenging consensual terminations of investment treaties.
Thanks for excellent lecture. I'm not negotiating investment treaty assets, but in the other personal topics or the characters of the treaty agreements. But see, my question is regarding the India technology partnership agreement, which is recently signed, although it is not coming to effect. But see, there is a very unique provision in that agreement, in that after 15 years, if the countries are not able to invest $100 million and if they are not able to create 1 million jobs in India, then India is having right to terminate the entire FTA assets. And so this is the two fees in that. First is this termination is regarding the it is going to the consultative, different consultative stages are there. So 3 stage consultations are there. That after each 5 years, they will jointly sit and they will analyze how the investment has taken place in here.
Yep.
And secondly, regarding this partial suspension, means it is not that the entire agreement will be suspended. Suppose out of 100 million, out of 100 million, if you are able to create 50 million, then the 50 million, accordingly, the agreement will be partially suspended.
Yeah.
So, what is your opinion on this?
Thank you for this addition. Yeah, I mentioned before that India unilaterally terminated, but indeed, of course, the aim would be to reach a consensus, and then we would have a consensual termination. And we've seen attempts here, like the Czech Republic. It's a little bit different here with suspension. Yeah, but it's also a tool trying to evade the termination with all its consequences and possibly the trigger of the sunset clauses. Now, a similar argument was interestingly raised in the last case that I put on the slide, on the Adria Group case, where the state also tried to argue that at least a joint declaration had the effect of a suspension of the treaty rather than a termination of the treaty. Under the Vienna Convention on the Law of Treaties, the tribunal did consider that argument, but it said that if such a suspension is to take place, then it needs to be very express. That would be satisfied here, but it raised skepticism. It didn't have to finally decide on the question because it was obiter dicta. I think that pretty much the same considerations apply to a suspension than to a termination in the modified form, the consequences set forth in the Vienna Convention. But otherwise, it's a power of the state under the law of treaties to suspend the treaty. Whether this would be considered an attempt to bypass the sunset clauses, an open question. Investment treaty tribunals may become suspicious, like in the case of the Czech Republic first amending the treaty. And it's these two forms, amendment and suspension, that expressly do not trigger sunset clauses. But that's express. So I'm sure investors will argue this is an attempt of circumvention, this is an abuse. And tribunals will have to evaluate that argument both under the law of treaties and under general principles of law.
Yes. And there is another thing, and they have now down this period of sunset clause 3 years.
Yes, that's true.
After 15 years, the 3 years is where they are giving. So, as for that, how they usually investment this AIT termination clause with the commitment, and how it can be measured that whether the tribunals are going to be posting.
So this is the way of amendment that some states, the most drastic form being just to eliminate the sunset clause. The less drastic form is to agree to an interim period or to expressly amend the sunset clause. Power to amend treaty is again one of the prerogatives of the contracting states. They are the masters of the treaty, so it's even less of an interference, of course, than a complete revocation with immediate effect. And I think it would be judged pretty much in the same way, with maybe tribunals being more open, because at least there is some mitigation in terms of the treaty's termination than if, like the EU member states did it, under pressure from the European Union, to even trying to retroactively get rid of these cases.
The outset that we really there to come across bilateral investment treaty, which should not have a sunset clause. But my question is, in case there's a treaty which does not have a sunset clause, can we still say that those obligations that arise under some sunset clause be applicable by using customer, especially If there's not parties.
And I think that question for once is a question that has a straightforward answer. The answer would be no, because under customary international law, there is no equivalent of investment treaty protections like for negative or treatback. It's interesting that the policy in treaty making has changed. So while you have about 99% of bilateral investment treaties containing sunset clauses, the free trade agreements that contain investment chapters or regional economic integration agreement contain either no sunset clauses at all or very, very short ones. So there's a clear shift in the policy of investment treaty making. But your question raised another point that's worth mentioning. Under the Vienna Convention and customary international law, if there are obligations owed by the host state to the protected investors independently of the treaty, those remain unaffected, of course. So to the extent that there are minimum standards under customary international law, like protection against uncompensated expropriation, they exist, but we are back to a period of diplomatic protection unless there is an international forum like a human rights court or another forum.
Thank you so much for being here. And just small questions. The first is, it seems to me that these bilateral investment treaties are still treaties between countries. Insofar as their establishment conditions on which their nationals can invest with each other. So they're not per se between a state and an individual. So insofar as these obligations are treated by these countries themselves, it seems to me in case of mutual recognition, they can agree to reciprocally remove these protections from each other's nationals. So I don't understand why, even in case of mutual recognition, these protections have to exist. My second question was triggered by something you said about 5 minutes ago in terms of expropriation, right? I think most of these treaties contain fair and equitable treatment clauses, which require you to treat the other countries' nationals fairly, not take their property and so on. So it seems to me that by terminating sunset clauses, it's a way to try to get past it. Like it's a way to not protect their investments when it's leaving the treaty altogether. Would you say that the violate treaty standards before various times?
It is indeed to some extent controversial whether investment treaties contain only interstate rights and obligations. It's a view that has been taken, I think, by 1 or 2 investment treaty tribunals, a view that's expressed in academia. I think the prevailing view today and the clear trend in investment treaty case law is to say that investors don't just act as agents for their home state when they resort to investor-state arbitration and enforce the rights under the treaty. It's quite a complex, bit artificial, I think, construction to say that investor is acting here in place of the state but has no rights under the treaty. So prevailing view, and I think that will continue and maybe even be stronger in the context of awards that we will see on consensual terminations, is these are treaties conferring direct rights, like human rights treaties, on individuals and legal persons. And indeed, if you take the first view that this is purely interstate, then there's no limit. Yes, of course, the contracting states can basically do whatever they want. The question arises if you accept that investors have rights, and there are again different nuances of these rights, but if you accept the basic proposition that an investment treaty confers rights on third parties, namely investors, individuals, or legal persons, and then all these arguments come into place that we discussed before: acquired rights of private parties, legitimate expectations, estoppel through sunset clauses, all kinds of arguments that we will soon see tested by investment treaty tribunals. Now, as to your second question, I think it was about the fair and equitable treatment standard. ICJ judgment I put up before on the screen in Bolivia versus Chile. Investigated and assess very interesting arguments made in that case precisely about to what extent investment treaty protections have already become general international law, customer international law. I mean, we have a network of thousands of treaties for decades in place, and they have been used very much with now more than 1,000 investment treaty claims having been adjudicated. So one instinctively would think this could have an effect on the development of customer international law, but the ICJ categorically said no. The ICJ said outside the scope of investment treaties, we still have no norm of customer international law or a general principle of law that would protect investors from unfair and inequitable treatment. We have the minimum standard of treatment of aliens as it already existed in the 50s, in the 60s. It's a question of interpretation then how far that standard has developed, but the ICJ was very clear. FET is not part of customer international law. You could argue, of course, both ways. You could say, yes, it has been recognized and applied in so many cases by investor state tribunals based on specific treaty provisions. It's say precisely because these treaty provisions exist and there is no principle outside those, otherwise they will be regarded as being superfluous. But at least from the most authoritative court in international law, we have a clear statement, a recent statement, 2018, that there's no development in that direction.
Many of these bilateral investment treaties have post-recognition.
Yes.
Now, in terms of the duration of the sunset clause varies from 5 years to 20 years.
Yeah.
So is it possible for the investor who invokes rights under a treaty which provides for a shorter sunset clause, can they use the MFN protection to claim protection for long period? Is that an argument that is from acceptance?
Yeah, that's the MFN clauses, of course, are another big issue in the context of ISDF reform. How we can reform them, we can make them clearer, but maybe someone invokes the MFN clause to invoke a second generation or first generation PIT. I think that the question whether an investor can invoke a longer period, it will generally be viewed as a question of the scope of the application of the treaty. First, as always, first caveat, it depends on the specific terms of the MFN clause, like with the sunset clause. Some MFN clauses are broad, potentially facilitating invocation. In that context, others are very narrow, where it is very clear that they would apply to specific treaty protections contained in the treaty, but not to other terms and conditions of the treaty. So if we're facing a broad MFN clause, I think that the host state would have a good position to argue that this forms part of the provisions of determining the scope of application of the treaty, like the definitions, like the temporal scope in general. And there is already a precedent for the proposition that an MFN clause cannot be invoked to expand the scope of the application of the treaty as such, but only to extend substantive treaty protections and controversial to some extent, but also to override specific conditions, preconditions to resort to investor state arbitration. But I think it's going to be an interesting argument if it's raised by an investor in one of the pending cases, because it's true, even the attempts to shorten. So in that sense, it's dangerous. It's a dangerous attempt by state if they leave the sunset clause in place, but shorten it. Would then an investor just turn around and say, MFN, I invoke the 20-year period in another treaty concluded by the host state?
I think we can bring the session to a close. And thank you once again, Claudia, for being so patient with all the questions.
No, it was a pleasure.
May I request all of you to convey your appreciation terms, I think, but we are certainly, as a standing ovation. Thank you very much.